Good morning. My task is to give an overview of the review of the Judicial Studies Institute that was conducted in 2004. The authors of that review were myself, Professor Ray Friel, both of us are of the School of Law in the University of Limerick, and Dermot Collin, who at the time was Director of Lifelong Learning in the university. The review, we were tendered by the Judicial Studies Institute to conduct this review. It was a public tender, and the elements of the project were threefold. One was to evaluate the existing program of events that was run in relation to judicial education. Secondly, to assist the Judicial Studies Institute in organizing events during the year of 2004. And thirdly, to assist the Institute in drafting a 3-year plan. So our work was informed by a number of considerations. The first, and I guess very important consideration, was you have to maintain judicial independence, that constitutional underpinning to the work of the judiciary. At the same time, however, we found that there was an element of judicial exceptionalism that is different, I think, from the constitutional independence of the judiciary, and that was something that had to be negotiated over the course of the year. The second consideration is, and this is a generic consideration in relation to professional development, is that shared judicial ownership is crucial. I use the term, by the way, continuing professional education, because that is the currently preferred term. So shared ownership. And thirdly, we did feel that general principles of CPE are applicable to the judiciary. Despite the independence of the judiciary, there are a lot of general principles that can apply with suitable modification or adaptation. And lastly, we said, well, the judiciary can be identified as a community of practice, just as you have communities of practice in other professions, in the legal profession, in accountancy, in teaching profession, and the health sciences and so forth. Communities of practice can come together. And it's not that the entire judiciary would be necessarily a community of practice. There could be subgroups or subsets of the judiciary that form communities of practice. You know, say judges doing criminal trials will form one community of practice. Judges assessing personal injuries might be another community of practice, etc., etc. Now, the quote at the bottom of this slide, I think, is also very important. We said you've got to see the judiciary as a national resource, and not something that should be taken for granted. And too often the judiciary are not seen as a national resource. And that investment in judicial education is an investment in the administration of justice. Part of the subtext to the report that we would eventually produce was to provide the judiciary with a document that they could use when negotiating with the state apparatus for suitable resources for conducting judicial education. So our methodology was this. We reviewed the Institute and its past activities, and the JSI were very forthcoming. They opened up all their records, all their papers to us, so we were able to do that. We conducted a national judicial survey about training needs and their educational needs, and also the judiciary's perception of the Judicial Studies Institute. We had a lot of interaction with groups of judges and individual judges. This was both, in some cases it was formal and structured, and in a lot of cases it was informal and relatively unstructured. We had a wide-ranging analysis of judicial CPE in comparable common law jurisdictions. We took 8 other common law jurisdictions and reviewed how they did judicial education there. We had a lot of direct observation. We were working with the judiciary for a year. We attended all the meetings of the board of the JSI. We attended meetings of subcommittees. We attended jurisdictional meetings, and we attended all the vast bulk of the education events over the course of the year. And then finally, there was external consultation. All these informed our work and the recommendations that we would ultimately make. So here was our finding about the state of judicial CPE in 2004. This is what the way things looked like when we reviewed it. The only statutory mention of judicial training comes in Section 19 of the Court and Court Officers Act of 1995. And in Section 19, you will recall, required candidates or applicants for judicial office to undertake to do whatever training would be directed by the Chief Justice or their court president. The Judicial Studies Institute then was established in 1996. It's a non-statutory, it was a non-statutory body, so it was, might call it ad hoc, for want of a better word. The board consisted of the Chief Justice, the presidents of the other three courts, a judge from each court, and a senior officer of the court's service. So that was 9 people in all. The Institute did not have staff, did not have a dedicated staff, it did not have a premises, it did not have a secure budget line. That said, however, the court service did provide administrative support for the work of the board of the JSI. The principal activities really were organizing the annual judicial conferences. So the conferences for the 3 courts, that is the district court, the circuit court, and then the superior courts. So the high and Supreme Court judges met in a single conference, and then the National Judicial Conference at the end of the year. So very much this was an annualized approach. So the JSI was just organizing 4 conferences. The relevant judges from the board would set up an ad hoc committee of some of their colleagues and then arrange the annual conference, arrange topics, speakers, etc. This was very much an annualized approach. There was no long-term planning. There was no CPE needs analysis. And crucially, there was no evaluation of activities after the events had occurred. Now, this is not a criticism. This is not to criticize the JSI at the time. This was just the way things were. And it was to be expected because the board of the JSI were serving judges in the main who were doing their full daytime job of being judges, sitting in court, then doing their research, writing up judgments, and so on and so forth. And their JSI activities was an add-on to a very heavy judicial load at the time. So too much more could probably not have been expected. We also found that there was a sense of disconnect between members of the judiciary and the Judicial Studies Board, and that a lot of judges had this type of view, well, what does the JSI board do for me, or how is it relevant to me, or etc., and so on. On the other hand, the conferences were well attended. Upwards of 80% of eligible judges attended the relevant conferences. The conferences in the main were held at weekends, that is, during judges' personal time. This partially changed in 2004, where the conferences were held on Fridays into Saturday. But up to then, they were held at weekends, and as I say, in personal time. And one of the core principles of continuing professional education in any event is this stuff should be done during work time, not leisure time or private time. So that prompted the consideration, were the conferences learning events or social occasions? Now, there's not a clear distinction in professional education. There's not a clear distinction between the two. You can learn in social settings, a lot of learning, informal learning and sharing of experience, which is a form of learning in the professional context, can be done in a social occasion, over a game of golf or over dinner or at a coffee morning or whatever else. But still, there was a sense that the social dimension to the conferences might have predominated, I don't know. And then lastly, some IT training was provided by the court's service. And we should say at this stage that the court service did provide a considerable amount of support at the time to ensure that the Judicial Studies Institute was able to function as it did. And it was not really a core activity of the court service. So our recommendations, they are bullet pointed here. And I'm going to go through them very quickly, and you might discuss them later in the day and see how far they've gotten. But first of all, we said the Institute should develop a 3-year strategic plan, and with a proper planning process, which would include extensive stakeholder engagement, that, and the principal stakeholders are members of the judiciary themselves, but there may be external stakeholders as well. We recommended the appointment of a dean of studies on a full-time basis, and that this would be a serving judge who would be seconded to the role. The model we had in mind is the appointment of a judge to the Law Reform Commission, so that model was one we thought might be adopted, and we envisaged maybe that statutory provision might be made. We reckoned that the JSI board should be expanded or enlarged, and in particular that there should be some external members of the board, bringing an external perspective, obviously, and also that a secretariat would be appointed, and that would consist of an assistant dean who would have a background in education and or training, and could be, for example, a seconded academic, that there would be a management level appointee who would do a lot of the event organization, the bookings, the logistics, and 2 or 3 clerical level or members of staff. Now I'm going to go down the list here. We also recommended the development of a multi-annual CPE program. Now remember that we said that the JSI was operating very much on an annualized basis, but that multi-annual planning would allow better coverage of the training and education needs of judges. And correspondingly, we also said training needs analysis would have to be conducted. That would be prior to developing your multi-annual program. We also recommended the development of different delivery methodologies. We canvassed the idea of formal recognition for CPE. And of course, nowadays, things have moved on quite a lot, that accredited learning is becoming a bigger feature in professional education in any event. And by accredited learning, I mean learning that is accredited by a university or equivalent body. We also thought that the JSI could be looked at as a research entity, that it could produce, for example, and prepare bench books for judges. It could conduct, we might call it applied judicial research, that where there might be need for information on this topic or that topic. We also recommended that the judiciary, or that the board, rather, that the dean and the dean's team would develop or submit a plan for a dedicated facility. By that, we had in mind not just an office for the JSI, but a facility that would be used for training needs, with the appropriate training facilities, laboratories, now I guess probably computerized facilities and so forth. But that there would be, we envisaged that there would be a space in which judicial education would be conducted. And we recommended the development of international links, and importantly, a ring-fence budget is, we said, was crucial. You know, it's the old rule, follow the money. If you do not have control of a budget, you do not have a ring-fence budget, then many of the things we recommended would be difficult to achieve. You need certainty in your budget line. At the time, we recommended about, or estimated that this would be about 1.2 million per annum. This would include both pay and non-pay costs. So to include the pay of the Dean of Studies, the Secretariat, and of course, all the non-pay costs associated with the activities of the Institute. So that in brief was a set of recommendations we made. I hope I've given you an idea, a flavor of how we went about the work, what our findings were, what the state of affairs was in 2004, and the recommendations we made for the Institute. And I look forward to interacting with you for the rest of this day. So thank you.